Good morning, Judge. Mind if I push this away? I have a loud voice. May it please the court, my name is Matthew Wolf, and I represent Ada and Howard Hayes in the matter of Wells Fargo Bank versus Hayes. I would like to reserve 5 minutes for rebuttal. We're here today following appeal from a judgment entered following a non-jury trial and an order denying a motion to disqualify. There were a number of issues raised in the appellate brief, but I want to focus on 3 here today just because of time constraints. I want to focus on the authentication of the original note, the plaintiff's proof of standing, and then the issue with the disqualification of the judge.
So on the note,
Yes.
you had a prior foreclosure that was dismissed because standing couldn't be proved, right?
I think judgment was entered for the defendant, but yes.
I thought it was dismissed because there was no standing.
It may have been. I apologize.
All right, that's no problem. Bottom line is though, the note and the allonge got filed in that hearing.
Correct.
It looks like.
Correct.
And it looks like at the time this suit was brought, the note and the allonge were people like, we don't know where it is. So you filed a copy and you brought a claim for a lost note. And then after you're into it, it was discovered that the note had previously been filed, right? Correct? You amended your complaint and your position today is that your standing relates back to the beginning because the original note was with the court all the time and it matched up to the other note, right?
I apologize for any confusion, Judge. I represent the borrowers, the defendants.
You're right. I'm stating the bank's argument, but nevertheless, the facts are all the same.
Correct.
So, right. So go ahead and, so you're going to attack standing on that point, right? The idea that the bank didn't have the note and the allonge, the original, at the time the suit was filed, correct?
That and the issue is that they're 2 different parties. If you look at the initial, the lawsuit from 2010, the party in that case was.
But it's an allonge endorsed in blank, right? So.
Right, but if you look at the Partridge case says the clerk of court's not your bailee. If you had a party in suit A that was filed in 2010, note stays within the court, dismissal judgment, then you have a new case in 2016, a new plaintiff, and that gets transferred from the prior case to the new case. Partridge says clerk's not your bailee. There's the Knoll case that allows that to happen, but that's when the same party is from the prior lawsuit as to the lawsuit before the court at that time. That's not what you have here. You have in the prior lawsuit, Wells Fargo Bank NA as trustee of the Harbor View 2006-12 trust fund.
So they're older.
In the prior case, that's who filed the lawsuit. In this case, you have Wells Fargo Bank NA as trustee on behalf of the holders of the Harborview Mortgage, Loan Trust Mortgage, Loan Pass-Through Certificates, Series 2006-12. That's a different party. There was no evidence, there was no testimony presented that the prior plaintiff in the 2010 case was the same plaintiff for the 2016 case.
But the note's the same.
Right, but if there was.
I should ask, are you all disputing that the note that got surrendered in the prior lawsuit is different than what was attached to the, indulgence, the subsequent plaintiff that's attached as an exhibit to that?
Well, there's an interesting, so the note that was
Yes or no? Because the judge seemed to say this looks the same, and I didn't see anywhere where I saw some problems with the fact that the judge was making this remark. I didn't hear anyone, or I didn't notice anyone saying, no. There's some differences in the note.
Between the 2010 case and 2016 case. The 2010 case, when they filed their lawsuit, there was an allonge attached. The allonge was endorsed in blank. When they filed their lawsuit in 16, there was a allonge attached that transferred the note from the original lender to Countrywide Bank, who transferred the note from Countrywide Bank to Countrywide Home Loans to then Countrywide Home Loans in blank. So there was a difference between the initial note in the 2010 case and the note in the 2016 case. Well, the allonge, right, affixed to
The notes were the same, and both allonges ended up with being in blank, assigned in blank.
They both did not end up being in blank, but the issue is that the plaintiff in the 2010 case is not the plaintiff in the 2016 case. If you look in the Partridge case was a situation where Chase Bank files their initial complaint and lawsuit. They eventually dismiss it. They leave the note in the court file. A year later, NationStar, a new plaintiff, files a lawsuit under the same note. Partridge says, the clerk is not your bailee. If you're going to transfer this from one party to another, you actually have to transfer. That's the whole point of being a holder.
They didn't have standing or the authority to transfer from the other case because they're not the same party?
Not transfer from the other case, that if they wanted to effectuate a transfer from party A to party B, they actually have to, as being the holder, physically transfer that note. That's the GWE case that we cited, where there was a substitution during the case, an assignment of mortgage, didn't assign the note, and the court came down and said, well, the note's been with us the whole time. How did you ever give possession to this new party? And you can't do that when the clerk's holding on to it. That's Partridge. What they would have had to do, if the party A is going to transfer it to party B, they would have had to get the note out of the 2010 case, give it to party B, and let party B then file their lawsuit. They didn't do that.
Why? Why couldn't they just effectuate a separate assignment?
They didn't do that, right? They could have, right? That could have remedied the issue. They didn't do so.
I'm sorry, you made it sound like the only way to transfer a note was to physically do it, the way you constructed that sentence, and that immediately jumped out at me. Well, no, I mean, they can just simply assign the right.
They can. If you're traveling under a holder, though, holder 673.1043, I think you have to actually be in possession of the original
It
note.
can also be by constructive possession, which
Right.
can be established through an agency, which can also be established through assignment or contract. You can establish a Bailey holder in a whole bunch of different ways.
I don't disagree. They didn't do so here. They wanted to use the clerk as their bailee when they transferred to party A to party B for the second lawsuit. They're going to argue here today that these are the same plaintiffs. They're going to tell you the plaintiff from the prior lawsuit is the plaintiff from this lawsuit. I've read both of those names of those plaintiffs for you here today. They're not the same. There's no evidence. They brought one trial witness who did not testify regarding who the plaintiff was in the first case and this case. They produced no evidence showing that the prior plaintiff was the same plaintiff. They could have produced a pooling and servicing agreement. They could have produced any document.
Where in the record would I find in the transcript that the issue of the different identities was brought to the trial court's attention? Where would I find that?
I'm sorry, Judge, I won't have that. I don't have that citation for you.
Move back over.
What they're going to, if you review their brief, even in response in their brief, they don't cite any evidence that these parties are the same. What they actually do is they cite what the lawyer argued at the trial. They're using the same argument I use with my 3 children every day. How are these the same parties? Because I said so. That's it. That's what they're going to come here and tell you today. They're not going to point to anything in the record, any testimony, any evidence, any documents to show that these are the same parties.
And all that was argued below, right?
It was argued as an issue of standing, that these are different parties, correct? So,
Well, hold on, because the issue of standing in different parties could be raised in a whole bunch of different ways. What you're saying here is that you're making a particular discrete argument that these entities are in fact, the party now traveling in the 2016 lawsuit is in fact a distinct and different entity that does not carry the same rights as the party, or has a different standing, doesn't have the same rights as the party in the a lot of dates floating around here today, 2010 lawsuit, or 2010 lawsuit. And that's my concern, is that discrete point brought to the trial court's attention.
yeah, I think that's a valid concern. I don't have a citation to the record where that was.
We can look that back. That's fine. I don't want to eat into your time.
Understood. But my argument is kind of that it's the opposite though. That they had to, if they're going to rely on the clerk being their bailee, they have to prove that it was the same party, and that there was no proof that it was the same party. There was no testimony, there was no evidence. They didn't submit anything. All they did was make an argument on the record. Even in their answer brief, all they do was cite their motion to amend the complaint. Their motion to amend the complaint, they said, well, this is the same party. That wasn't verified, that wasn't authenticated. They didn't put any evidence forth that was the same party. And I think Partridge would control there because the clerk is not your bailee. Had it been the same party, then I would agree with them. Noel would control. Partridge says you can't do that. I think another big issue was the authentication of the note. This was a Zoom trial. Zoom trials are naturally different than being in person. When the parties went forward to admit the note into evidence, it was the judge who authenticated the original note and not the trial witness. SPS, the only witness called by the plaintiff, said SPS never had the original note. never in their possession, that it was always with the court. So
My recollection of that testimony is the copy of the note and was shown in the Zoom trial to the witness.
correct.
And the judges got the original note because it's been previously filed in a court file, and so the judge has it. And the judge compared the two and said, yes, this is the original note. Now, the judge is the fact finder, there's no jury here. And you have a problem with that? That's what the judge's whole function is.
Correct. He's the fact finder based upon the evidence provided to him. But if we look at how this evidence was authenticated, it wasn't the judge reviewing the evidence provided by the witness. It was the judge confirming it was the original and the witness relying upon that. Here's the testimony. Has SPS ever been in physical possession of the original note? As I stated, it's been with the court. It was filed in the prior action. I don't remember when the prior action was filed, so no, it's always been with the court. So is it your belief that we have the original note here today based upon the judge's statement that he has the original note? I have no reason to disbelieve anything that the judge says. If he says he has it, I believe him 100%.
It's always the right answer, by the way.
But, right, but that's the witness relying on the judge authenticating.
So how should the judge have handled it? He's sitting here in the Zoom hearing, he opens a court file, sees what looks like an original note, and he's more or less not testifying, he's just saying, I have it here, is what he's saying. And he called it an original note because that's what it looked like, and it was in the court file because of the prior hearing.
So I've done many of these Zoom trials. What typically happens is the original note is usually a business record of the testifying entity. And they would have a copy from their business records that they would have pulled and sent the original in.
So
And you
if
put
the
your,
judge would have said, I have what appears to be the original note, would you be here fighting this?
if the witness still testified that her knowledge was based upon what the judge said, then yes. Because it should be the witness that should be soliciting that testimony and a judge relying
But the
upon it.
witness is in Zoom and can't really handle the note like the judge is.
I agree, and that's where a
So we
situation.
just can't have Zoom hearings on these anymore?
No, I believe we definitely can have Zoom hearings, but the issue here is SPS never had the note. She could not authenticate that original note. It was never in their possession. Even the copy must have just been given to them because they couldn't have copied it. I've done these Zoom trials where they have the original note, they put it in their records, they scan it, they have a copy now, trial goes
What
forward.
about Ortiz and our subsequent case that tags along with Ortiz, if you will?
Yeah, so the Ortiz presumption that there was a copy of the
I'll
note.
correct something right there. Ortiz, to my mind and to my reading, Ortiz does not create a presumption, and our subsequent case that applied to Ortiz does not say it's a presumption. It's rather what it says, and this is key to the point you're making, it's evidence.
Understood. In Ortiz, the plaintiff had possession of the note at the time the lawsuit was filed. In this case, they did not.
Well, right, but we know why, right? There was a previous lawsuit that it was filed in. So what you're saying is the bank should have gone to the court file, retrieved the original note, taken it to the hearing. And so for the Zoom hearing, the original note, the copy would have been present in front of the witness instead of the original being with the judge and the copy with the witness. Isn't that what you're saying? That sounds really cumbersome. In the age of technology, we really don't have to do those kind of things anymore.
What I'm saying is that the witness is the one who needs to authenticate this document. And they would do so if it was part of their business records. They could have a copy. They could say, we had the original, it went to our original filing department, we scanned it in, it was held in a safe. When we filed our lawsuit, we gave it to our lawyer and they filed it. What I have in front of me, sitting in my Zoom office, is a copy of that document. And what we've given you is the original. That would be the witness authenticating that document. We don't have that here. SPS never had this document. SPS can't confirm this document. All SPS could do was what she did at trial. She said, well, if the judge says that's the original, I'll agree with the judge 100%. Not, judge, that's the original based upon our records that we've submitted to you. It's the opposite here. The judge is the fact finder, but they're the fact finder based upon what's provided to them. It's gone completely different here. And with the Ortiz question, I think the issue is they didn't have the note. So you can't use the Ortiz case because when they filed a 2-count complaint, one for a lost note.
You do have a court saying, I have here an original, and you've got a copy that appears to, in all regards to the matter, match it. which under Ortiz, and I'm looking, I can't remember our court's case name, I'm always bad at case names, that adopted the reasoning of Ortiz, although it should tweak the language a little bit, but that is evidence in and of itself.
And you're at 15 minutes, just so you know. It's your time, use it any way you want.
I would like maybe one more minute just to touch on the disqualification. I think the court erred in denying that motion for disqualification. What you had during the case in chief was a judge already making a determination that there was a breach of contract. He said on the record, mixed up my notes now.
It was, we have a mortgage that hasn't been paid in 11 years.
We have, exactly, thank you, Judge. It was,
I'm just trying to move this case along.
I'm trying to move this case along. We have on a mortgage that hasn't been paid since 2011. This was made during the plaintiff's case in chief. The defendant hadn't had a chance to respond yet. Would a reasonably prudent person determine whether or not they would receive a fair trial from that? I would sure have an issue if during the case in chief on a breach of contract case, there was already a determination that there was a breach and the judge was just trying to hurry the case forward. I think it was error for him to deny that, and I would ask the court to overrule that as well. Thank you, Judge.
Jeff, 4 minutes.
Judges, thank you.
I don't know if it's morning or afternoon, but good morning, Your Honor. Good morning, Your Honors. May it please the court, Allison Murat for the appellee. In this case, the plaintiff sufficiently proved it is the holder of the note and therefore entitled to foreclose. The evidence is not lacking. It is competent and substantial. There's no case law cited
What
in the.
about the disqualification issue?
Yes, Your Honor.
Some things were said which are concerning, right?
No, Your Honor. Not under the objective standard, the reasonable person standard.
Well, if the judge said in my foreclosure hearing that there hadn't been a payment made on this in over 10 years or whatever the judge exactly said, I'm just trying to move this case along. I would say I'm probably not going to win this. You know, I mean, I would probably say that.
I think if this statement is taken out of context, but if you look at the transcript, that was the testimony that was provided during plaintiff's case, that this loan had been in default at that point, that the court was forming mental impressions and opinions while the case is being presented and commenting on it, which the court is permitted to do.
Couldn't a reasonable person at that point in the case would have reasonably draw an inference of shoot, and this judge is seeing me as a deadbeat. I haven't paid my mortgage, move the case along. Sounds like I mean all this stuff about standing, about the clerk is a bailey, whether or not we have, the same parties. It's just, it doesn't matter. I haven't paid my mortgage and the judge wants to move the case along. Why couldn't a reasonable person have an objectively based fear that they're not going to receive a full trial on all the other issues besides the nominee?
I think that that would be a subjective fear, but when you look at the fact that this was a bench trial, the judge is tasked as being the fact finder. The judge throughout the trial is moving the case forward. He's charged with managing his docket and moving the trial along in an efficient manner. And that was the testimony before the judge at that time. The case law specifically says that judges are allowed in these instances to form mental impressions and opinions on the evidence as they're presented.
You can absolutely form those opinions, but when I was a trial judge, I used to keep a little sticky note nearby that would say, think it, don't say it. For the very reason that once you put something out there, when you start talking aloud about what your mental impressions are, people can read that wrongly as you having formed an opinion on the case, rather than a mental impression that is subject to change.
The judge also followed up by saying, inviting cross-examination, prove that you are not in default. So the judge was not prejudging the issue. There's no indication that the judge made up his mind before this trial started. These were statements that were made as the trial was progressing based on the evidence that was presented. It's not a statement of personal bias by the judge against this defendant. It's a statement about the evidence.
I mean, you are correct. The judge did not go so far as to say, you know, I don't think there's anything to this, or, you know, I don't need to hear anymore. We deal with these all the time. Let's just get this done so I can end it. I mean, we didn't get, you're right, we didn't get that.
Correct. And the defendants were not prejudiced from putting on their own case. They were allowed to call their own witness. They recalled our witness. At the end of the trial, the judge didn't rule for the plaintiff right away. The court reserved ruling. I think the judge said he was going to cogitate, which is a fancy word for ponder or contemplate the evidence. And then
Judges do, I think.
right, and make its ruling. So this was a fair trial. This was not a case where the record does not show that the judge had any prejudged bias against these defendants before they came into the courtroom. And the record does not show that the judge even had personal bias against these defendants as the case was progressing. This was the testimony and the evidence that was presented that these defendants, or that the defendant, Ida Hayes, the obligor on the note, was in default.
And at the end of the day, on that issue about what he did make his comments about, was there any dispute about when the last payment was made?
The default date in the complaint is 2011. The original default date was 2009. So the date was moved forward actually because of then existing law on statute of limitations. But there was no dispute that there was a default. If your honors have any other questions on the disqualification issue, the other part of that is that the motion is legally insufficient. It was only signed by Howard Hayes. It was not signed by Ida Hayes, the borrower on the note, the one that was responsible for the payment. It was also not signed by the trial attorney. It was signed by a different attorney. And there was some allegations that judge was laying foundational questions or asking foundational questions for the parties. But the rule requires that the motion allege specific facts. And so the motion was not specifically alleged in that regard. Back to the standing issue, I think it's important, and I want to be clear on this, the plaintiffs between the two lawsuits, the 2010 and this lawsuit, they are the same plaintiff. You can look at the plaintiff name and see that. The plaintiff is the trustee. That's the first part. Wells Fargo Bank N.A. as trustee. Any difference in the plaintiff name is immaterial. There are some differences in verbiage about the trust name, but the trust is still the same. It's the Harborview 2006-12 trust. But the case law tells us that the plaintiff is actually the trustee. So you have Wells Fargo Bank N.A. as trustee as the plaintiff in the first action. You have the same plaintiff in the second action. There was no counter evidence presented at the trial to show that these plaintiffs are different. So this case falls squarely under this court's decision in Knoll. And the plaintiff in this case still had the ability to control the note. The plaintiff moved in the prior action for the return of the note. The note was returned to plaintiff's counsel. There's a court order returning the original note to plaintiff's counsel. 2 weeks later, plaintiff's counsel signs a certification of note possession that the note is at plaintiff's counsel's office. And then the original note is filed in this action prior to trial. That notice of filing original note is marked received by the clerk of court. And Clark from the 4th District tells us that that's sufficient to remove the note from the stream of commerce. And when you get to trial, the original note was already with the court. I think your honors already touched on that the court confirmed it's the original note. That's the court's function as the fact finder. And the court didn't just look at this original and say, yes, I have the original. The court also asked for plaintiff's counsel to put up on the screen the copy that the witness was testifying to, and the court compared the original and the copy and confirmed that they're the same. So there's no issue here about authentication or best evidence. This case falls under Clark. It's different than the cases cited by the appellants in their brief. It's not Radigan. That was a loan modification issue. It's not Kachik, where the original launch was not filed with the court. Here, you have the judge performing its function as the fact finder, confirming that the court has the original note. It was filed with the court prior to trial. This is a Zoom trial. What else are you supposed to do? So there's no issue as to best evidence. And as to standing, we have competent substantial evidence. The standard's not clear and convincing. It's competent and substantial. That's relevant evidence that the reasonable mind would accept to support the conclusion reached. So you have a court order from the prior action ordering the return of the original note, not just the note, but the original note that was filed in that prior action to plaintiff's counsel. So we produced that order as evidence. We produced a copy of the original note that was filed in that case as evidence. It has an exhibit sticker on it. Still, I believe it was Exhibit 2. And then we have the certification of note possession from plaintiff's counsel in this case, saying after the note was returned, it was located in plaintiff's counsel's law office.
So your argument, though, is that you had constructive possession of the note at the beginning of the lawsuit? Is that
Yes.
correct?
Yes, Your Honor.
Constructive possession relates to the fact that it was in the court file from the previous lawsuit.
Yes, and that's the Knoll case from this. So again, the plaintiffs are the same. There's a lot of talk about Party A and Party B, and there needed to be a transfer. The plaintiffs are the same. It's Wells Fargo Bank, NA, as trustee. There's no evidence that these two plaintiffs are different in any respect other than immaterial differences in the verbiage. And in the briefs, the appellants rely on a relevant case law about a non-holder in possession, and you have to prove every step in the transfer process. We don't have to do that here. We're talking about a holder situation. We have a blank endorsed note. Check my notes to see if there's anything else I need to touch on. And as far as the allonge's existence, I think there was an argument in the briefs about we didn't prove that the allonge existed at the time the suit was filed. The allonge with the 3 endorsements endorsed in blank was attached to our original complaint. There's a case from the 5th DCA, it's Laird. Logically, that allonge existed. It was attached to the original complaint. We can see that it existed. It doesn't matter if that allonge with those 3 endorsements did not exist 10 years ago. What matters is whether it existed at the time that we filed this lawsuit, and we have photographic proof that it did.
And then the copy of the note and the note that was in the court file, just the notes, were identical, is that correct?
Identical, yes.
The only difference is these 2 allonges, the first of which is just endorsed in blank, second of which talks about a series of transfers ending in an endorsement in blank.
Yes, Your Honor. So
Anybody that's holding it, that note is the holder.
exactly.
Okay.
And so regardless of if there's a confusing assignment of mortgage to another entity, it doesn't matter because we're talking about a holder status. In this case, the assignment's not conflicting. It's just from MERS as nominee for the original lender to our plaintiff. So it doesn't address the intermediate successors, but it's still consistent with our plaintiff being the holder of the note or the right person to enforce it. Now, there was mention about the copy of the note attached to the original complaint in the prior action from 2010 only had 1 endorsement. Again, that doesn't matter. That was a 2010 complaint. There is a copy of an original note that was filed in that action that we produced as evidence that has all 3 endorsements. I think that was filed in 2015 in the prior action. It has 3 endorsements, the last of which is in blank. And then subsequent to that, you have a 2018 order directing the return of the original note to plaintiff's counsel. You have a certification of note possession, then you have our lawsuit with this allonge with the 3 endorsements, the last of which endorsed in blank is attached. So we've connected the dots. Again, Judge Lucas mentioned there's many ways that you can prove standing. Could we have presented different evidence? Sure, there's lots of different ways that you can prove your standing, but under the competent substantial evidence standard, we met our burden and there is not any counter evidence that would warrant reversal in this case. We ask the court to affirm.
So 4 minutes, Judge?
Yes, sir.
Okay, I'll be quick. Judge Lucas, to your question earlier, I went back in the transcript, page 119 is where the discussion starts regarding the 2 separate parties. That was made for the motion for involuntary dismissal. You'll see 119 and 120 of the transcript. I don't have the record of the supplemental record.
Okay, so this is an involuntary dismissal argument, that's when it was raised for the first time?
Correct. So counsel makes this argument, and I don't disagree with her, that they had to come forward with competent substantial evidence. She makes this claim that who the trustee is, the trust is immaterial. My question is, where is the competent substantial evidence that these trusts from the 2010 case and 2016 case are the same? It doesn't exist. It's their burden. not ours, to come forward. If they're going to use the clerk as the bailee, they're going to rely
We know
upon
it's the same we know it's the same trustee.
same trustee, right? But same trust.
Who would be the, yeah, I get that. Who would be the one acting on, whichever trust, assume they're different trusts. Who would be the entity acting on their behalf to act as holder, who would be able to establish their ability to fly the flag, so to speak, for the proper trust? It would be the trustee.
Right, but that's not the issue. The issue is if these are separate trusts, 2010, 2016, that note was kept in the court file. Partridge says if you're going to change plaintiffs from party A to party B, you can't use the clerk as your bailee. That's the issue. I agree. If they're the trustee, they probably have the right to file a lawsuit. We didn't see a pooling and servicing agreement or anything like that, but yeah, I would agree with that. That's not the issue. If trust A is different than trust B, read Partridge. You can't let the clerk be your bailee. Knoll's different. Knoll was when Deutsche Bank was the initial plaintiff, case dismissed, and then they filed a second lawsuit. Exact same plaintiff. The court says, hey, it's okay if you left it in here, you don't want to put it back in the stream of commerce, we're fine with that. Partridge doesn't say that. So if you're going to effectuate a transfer from A to B, you actually have to have that note to do so, or some other evidence to prove that. So I asked the court, where's the competent substantial evidence that party A in 2010 is the same as 16? It's not there. It's, again, because they said so, and that's about the only thing they can argue on that. There was a dispute about payment. This was argued at trial. They did something where they rolled default date forward. So there was an issue regarding the default date. The last thing I want to touch on is this idea that they're holder. When you're a holder, you have to prove standing in a mortgage foreclosure in two instances. When you file the lawsuit and at trial. If they're going to proceed as the holder, they had to prove that they were in possession of that note at the time they filed the lawsuit. They admitted they were not. It was a 2-count complaint, lost no count. They didn't have it. So they can't prove their status as a holder in this situation, especially when the clerk was when they wanted the clerk to act as their bailee. The last thing I want to say, how's my time? A minute?
Yeah, a minute.
They rely on a couple cases regarding the differences in the trust names. They rely on the Ginsburg case and the Clark case. And the Ginsburg case was a situation where there was a difference between the endorsement and who the plaintiff was. And the court said, well, that's fine. And then in the Ginsburg case, there was a difference between who the plaintiff was and who the power of attorney was. None of those cases stand for the instance that if there are two separate plaintiffs and that note remains in the court file, can that second plaintiff file a lawsuit? That would be Partridge, and I think Partridge would control. Thank you for your time today. I would ask the court overturn the judgment, enter judgment in favor of the defendant, or in the alternative, overturn the order denying the disqualification, disqualify Judge Girotka, and have this matter reheard. Thank you.
Both did a great job today. These cases are not always easy to make clear. You both did an excellent job doing it.
Thank you, Judge. I appreciate that.
We're adjourned to deliberate these cases.
All rise. Thank you.